SwayamPrabha. Digital India. Educated India.
I am Devajit Kumar Sharma. I will be taking this particular lecture on schools in criminology as part of the course on criminology, penology and victimology. Now, the schools of criminology, perhaps you all must be wondering why these are called the schools and what is there in criminology to look at so far as the schools are concerned. I will explain to you every detail of this particular topic one by one, but at the very outset, let me tell you that the whole phenomena of crime is such a phenomena that is quite complex for any person to understand and also to define. You would appreciate the fact that crime per se is not defined in any criminal law for that purpose. What is being defined is only offense. So, that way the crime as a phenomena is a matter of social definition rather than legal definition. Now, the second thing that would come to your mind is what is the crime that someone is committing. Now, in case if somebody is found to have violated any law, we say that the person has committed crime. But the point here is the immediate thing that you find prescribed in the statutes is that what the crime is. But maybe many of us may not be aware about the fact why the particular crime is. That means, when you start thinking from what the crime is to why the crime is, that is where the significance of studying the causes of crime become important. And criminology as a discipline takes care of that aspect. That means, it delves into understanding reasons behind commission of crime. Why people commit crime? There have been innumerable explanations from time to time of the underlying factors behind people committing crime. As I have said, it is such a complex phenomena, it cannot be put into any kind of mathematical formulation, like what we have is a plus b whole square is equal to a square plus twice b plus b square. That is not the case in case of crime. It can or it may, it always does vary from place to place, from time to time, from context to context. Not only that, as I have told you that criminology takes care of the causes or the reasons behind commission of crime, but also it takes into consideration the responses of the society towards such crimes. That means, how does society respond to the commission of crime by individual members in the society. Now, when I say the responses, it invariably implies the whole notion about the punishment. Though we have a separate field altogether, that is penology, which takes care of the punishment aspect, nevertheless criminology is also concerned about the reaction of the society towards the commission of crime. So, one, the reasons, second is the reaction, and the third, based on the prevailing crime situation at a given point of time, what kind of laws are being made by the people. When I say the laws are being made, that means in the collective wisdom of the society, how people consider it appropriate to make criminal laws in response to the crimes which prevail in the society. So, the three things as I have told you, the causes, second the responses, and the kind of laws which are created or enacted for the purpose of addressing such situations in society. That is precisely the definition of criminology given by Sutherland, and he defined criminology as the body of knowledge regarding crime as a social phenomena that includes within its scope the process of making laws, of breaking laws, and of reacting towards the breaking of laws. So, this very definition of Sutherland I have tried to put it in simple words with the kind of examples that I have given you, and I hope this will make the things easier for you to understand and appreciate. Next, you may also realize the fact that we have criminal statutes like the Indian Penal Code, which tells us about a particular offense. Now, if X does this in under certain circumstances or conditions, what kind of offense it may lead to, or what kind of the acts amounting to what definite offense under Indian Penal Code, or for that purpose any special or local law. Now, the whole adjudication process does not end in that. What I mean to inform you here is that the adjudication of justice starts with identifying what kind of offense has been committed and ends with the kind of punishment that needs to be given. But it is where you will find that in the purview of the Indian Penal Code or any special law for that purpose, most often the punishment remains the discretion of the judge. That means, in the Indian Penal Code also you will see that there are provisions, almost all the provisions in the IPC, wherever the aspect of punishment has been taken care of, it is being stipulated that the punishment may be up to 10 years, or it may be up to 7 years, or it may be up to life imprisonment, but you may not find a definite punishment for a definite crime. Now, the fact that up to 10 years or up to 20 years or life imprisonment, whatever may be the case. Now, for the same crime being committed, one may be liable for life imprisonment, another may be liable for 10 years of imprisonment, another person may be given only 5 years of imprisonment. The discretion which is exercised by the court and the magistrate and the judges, it also depends on the kind of understanding they have regarding the causation of crime. This also takes us to the very aspect of just desert, or the fact that the punishment should be proportionate to the crime being committed. Now, here when it comes to the discretion being exercised by the courts, so far as the punishment into a particular offense is concerned, we can say this is something that is being influenced by the parallel developments in the field of criminology. The idea behind my giving you this different example is that you get yourself involved in the way the criminology has been shaped from time to time. That means, we have, when we talk about the schools, we have two major schools, that is the classical and the positivist school, but the fact that the punishment ought to fit the criminal depending on the circumstances and the antecedent and the precedent of the crime, that is something you can say that being influenced by the positivist thought or the positivist school of criminology, about which we are going to discuss in detail in the subsequent discussion today. Now, to take you to the beginning of this, again the particular discourse, or with the examples that I have given you, if I have to put those things in the proper place, I would say that the criminology is but the scientific and humanistic understanding of the conflict between the individual and the society. That means, how does one interpret criminal behavior and offers more scientific and humanistic solutions to the problems of crime in the society. That is what the approach or what the mission of criminology all about. And it is always dependent on the fact that the solutions to the crime in the society may not be always found in a very deterrent kind of an approach or in a retributive kind of an approach. Rather, there could be other ways of looking at crime and addressing the situations of crime in the society. Now, when I say that, let me also remind you of the fact that alongside the criminal justice system that is prevalent in the country, we also have the similar system, if I may call them similar, because they are not the same, but then they have certain aspects similar to the criminal justice system, namely the system of probation, namely the juvenile justice system, namely the parole system. Now, why these systems were kind of how these systems were formed or how these systems evolved alongside criminal justice system? The answer again lies with the developments in the field of criminology, because these systems rely more on the kind of criminal, the kind of person who has committed the crime, rather than what kind of crime has been committed by the criminal. That means, you can see that the emphasis is on the person who commits crime rather than the kind of crime that is being committed by the person. That is, again, you will realize soon hereafter that this is something that has come from the understanding, or the whole this principle has come from nowhere but the positivist thoughts in criminology or positivist school in criminology. Now, it is this particular discipline is the scientific study of the causes and prevention of criminal behavior, informed by normative, legal and philosophical perspective, which are of course empirically verifiable, and they are based on empirically verifiable facts. That means, like all other developments in the field of human civilization, be it in the physical world, that is we have the physical sciences, in the medical world we have the medical sciences. If you talk about the sky and the stars above you, again you have the astronomy. Similarly, there is this particular scientific study or the domain or the discipline which takes care of or which scientifically looks into the crime in the society, that is but the field of criminology, that is but the study of criminology. Now, going into the history of criminology, or rather I would say that the very genesis of criminology, invariably it lies in the mother discipline called sociology, and as you know that the father of modern sociology, Auguste Comte, he has given certain positivist way of looking at the problems in the society. That is from precisely from where even criminology can be started to have evolved. However, what must be taken cognizance of here is that criminology over the years, as it developed, it has developed to be a very unique and separate discipline with certain similarities of course with the sociology, and rather I can call it as a specialized domain altogether. Today, criminology as a discipline not only draws from sociology, but also it draws from every other discipline, including medical sciences. It is a multidisciplinary, I would call it, domain which draws heavily from all social sciences. At the same time, it also draws from other behavioral sciences such as psychology, and also the medical sciences when it comes to the biological schools of criminology and things so on and so forth. Now, when it comes to the schools in criminology, as I have told you, there are two major schools. These are the classical school and the positivist school. But that does not make the story complete. Why do I say this? Because it is not that the schools came or evolved just like that from nowhere. Every school has got its own history altogether. Reason being, the crime is something that is not that never started when the classical school emerged, neither it started when the positive school emerged. Crime is something that has always been there in the society, beginning from the time when people started living together. So, we have different conceptions of crime, maybe the different concepts and conceptions we are going to take up in details in our next lecture on the theories of crime, because this particular lecture is on the schools of criminology. So, I am not going to look at those parameters of the concepts relating to crime, but what is needed to be taken note here is that there existed certain ideas even prior to the coming of the classical school. As you may be aware that the classical school, we have two important propounders, one is Beccaria and other is the Bentham, and Beccaria is well known to be the father of criminology, about whom we are going to discuss after some time. But before we delve into the whole discourse on the classical school and the positive school, and also to see how these schools are different, let me take you to the pre-classical ideas on crime which prevailed prior to the coming of the classical school. When I say the pre-classical ideas, that means these were ideas which were prevalent at points of time when the classical school did not emerge. Now, what were these ideas? Those ideas which prevailed in the minds of people, but there was no any coherent or comprehensive study of crime and punishment which actually existed at that point of time. Now, these ideas, which I call them as pre-classical ideas, is not present in the present society. Even you find that certain notions of pre-classicalism or the pre-classical ideas still prevail in some parts of the country in India, where we have practices like witch hunting. There are states in India today which have legislated statutes against practices such as witch hunting, and the witch hunting is something where you believe that if something goes wrong in a particular location or particular village, you make one individual responsible for that, and you try and give the most brutal and most horrifying treatment to that particular person, to the extent of even killing that person, and this kind of practices are still prevailing, for your kind information here. Now, when I talk about, or when I told you about witch hunting, this perhaps gives you a clear indication about what kind of pre-classical ideas must have prevailed at that point of time. Pre-classicalism is something that prevailed during the Middle Ages, where when the superstitions and the fear of devil possessions dominated human thinking. That means, people believe that if somebody committed crime, that person committed crime because certain devil tendencies were operating inside that particular person. I mean, see the kind of superstition or the level of thinking that prevailed. People never committed crime out of free will or out of own volition, but because of the fact that certain evil tendencies were somewhat regulating them from inside. And that is why people who violated laws, or rather that time it was not laws, but the religious norms and social norms, were believed to be witches. That is from where the word witch hunting perhaps came up, and possessed by devils or demons or of inferior blood. And that is why it was believed, and even it is still believed in the practice in the regions where similar practices are prevalent today, that these people are of inferior blood. That means, as long as these people live in the society is not going to do well, society is not going to progress. It is because of the existence of such people or the fact that such people live in a particular location, everything in that particular region goes wrong, be it natural calamity, be it illness in that amongst the elderly people or people, children dying out of different diseases. All these factors are attributed to the fact that a witch is somewhat living in that particular place. Now, because of similar ideologies which prevail, and let me again inform you the fact that these were the ideological standpoints which can be seen or that can be traced over the period of time in which the criminology evolved. It is still evolving, it can never be static. The manner in which crime cannot be defined in one particular way, or the offense cannot be defined in one particular way. Of course, the offense is defined under Indian Penal Code, but that definition of offense is only for the purpose of interpretation of Indian Penal Code, not beyond that. Now, these things are so universal, yet so not static, they are so kind of evolving that there cannot be one particular definition which signifies the factors or the ingredients of it for the times to come. Now, that is why what was done as part of the pre-classical ideologies was that they used to use torture to extract confession, and people who were convicted of violent or theft crimes suffered extremely harsh penalties. They were given the worst of all punishment for the crimes being committed by them. But let me also remind you that there was no code as such, there was no justice system which prevailed. It was the people themselves decided for what needed to be done for those who committed wrong in the society. In Europe, for instance, crime and criminal behavior had been explained for over 1000 years by spiritualistic notions before the advent of modern age. Central to the spiritualistic thought was something called as demonology. That means, before criminology, it was demonology, where it was proposed that criminals were possessed by demons that forced them to do wicked things beyond the control and restraint. Now, we have this French ancient regime called regicide, about which Foucault in his connection provides his own understanding of it. Rather, he provides an account of public execution reserved for the greatest of all crimes under French ancient regime, that is the regicide. In his own words, and I quote, "The flesh will be torn from the breast, arms, thighs and calves with red hot pincers, his right hand holding the knife with which he contained the said parasite, burnt with sulphur, and on those places where the flesh will be torn away, poured molten lead, boiling oil, burning resin, wax and sulphur melted together, and then his body drawn and quartered by 4 horses, and his limbs and body consumed by fire." So, what I am trying to bring to your notice here is that that was the level of treatment which was given to people who committed wrong during that period of time, what we call them as the pre-classical understanding of crime and justice. Now, moving to the classical school. As I have told you that the pre-classical ideas or the way people look at the phenomena of crime in the society, it dominated European thinking for a long time. And what actually happened was, such kind of pre-classical notions, it formed the basis of criminal justice policies in most of Europe at that point of time. And crime was more often identified as sin. When I call them sin, that means something against a religion. And it was believed that the state had the moral authority to use all possible means to deter such criminal from the society. And reason cited was that since crimes were considered to be sin more or less, the state was acting on behalf of God. Anything that was against religion was to be cursed with an iron hand, and the state had the divine power to do so. That is the thinking that prevailed at the beginning of the classical school. Now, the classical school started challenging such kind of spiritualistic notion about crime. That is the important paradigm shift which can be observed here, is that it started challenging those spiritualistic notion with its own philosophies, with its own ideologies, and in fact, the social contract thinkers at that point of time started challenging such spiritualistic notions about crime. Now, when I talk about spiritualism, spiritualism is not something that is not there today in our society, is still there. We still believe in the whole certain spiritual practices or religious practices, but the important facet of the pre-classical period was that everything was believed to be the acts of God, which came to be heavily challenged by the classical school, and that was the starting point. I would like to emphasize is that of the more scientific way of looking at, or rather if not scientific, it is more of a very systematic way of looking at crime. I would like to repeat this particular point. The classical school of criminology was the starting point of looking at crime more systematically. When I say systematically, that means people started more seriously to think about crime, what may be the reason and how to address this crime. Before that, it was all people used to leave it in the hands of Almighty, that it is the God's will. So, we have to eliminate such people from the society if the society has to be saved or society has to be safeguarded. Now, as I have mentioned to you earlier, the scholarship in criminology has its roots in the classical school propounded by Beccaria and Bentham, and indeed the classical school was influenced by the thinkers like Montesquieu, Bacon, Rousseau, Hume in explaining crime and punishment from naturalistic and rational approach as opposed to the dominant spiritualistic explanation. Importantly, two events in the history of human civilization, one the American Revolution of 1765-1791 and the French Revolution 1789 to 1799 were guided by the naturalistic ideas of social contract philosophers, had an impact on the emergence of classical school. Now, what the classicalists believe? The classicalists believe that it is the free will of people rather than any act of God or any like devil tendencies inside a particular person who is compelled that person to commit crime. The classicalists they say that it is not any spiritual thing or not any evil or devil tendencies which really control human being, rather it is the free will, and this free will that all human being possesses guide people to make rational choices. When I say rational choices, as human beings we have our own mind and we make decisions in life based on our own application of mind. Now, if that is so, when some person commits a crime, that is something that person does it deliberately. Now, something is being done deliberately implies that the person can also deliberately commit crime. That means, human being the most rational being in this universe does everything out of free will, so does human being also commit crime out of free will. Now, if crime is being committed by any human being out of free will, that human being should also be held responsible or liable for the repercussion or the implications of it. Now, that is where the very justification of punishment comes in. That means, if I commit wrong, I am doing it out of my own volition, out of my own free will, and I deserve to be punished. That is the central tenet you can see. Therefore, for any act of crime, the punishment should be proportionate to the gravity of the crime being committed. One of the fundamental things that classicalists they were arguing, that for every crime, the punishment should be proportionate to it. It should neither be more than the proportionate to the crime, neither it should be less, but then it should be in proportion to the crime being committed. But what the classicalists perhaps ignored or they did not take into account is that not every person commits crime under same or similar circumstances with a similar kind of background. That is something what the positivists they try to capture, and that is what they advocated for. Now, without discussing much about the positivist school, when we are discussing about the classical school, this is where the very emphasis or the focus should lie, that the classicalists believe that the punishment should be in proportion to the gravity of the crime being committed or the injury which is being inflicted, irrespective of the factors subjective which may be subjective to the offender. Indeed, you can say that at a point of time when the countries around the world enacted their own general criminal statutes, including our Indian Penal Code, perhaps at that point of time, as a matter of philosophy, classicalism was perhaps prevailing. Now, if you look at the very scheme of the Indian Penal Code, you will observe that they have been heavily influenced by the classicalist way of looking at things. Now, the very emphasis of IPC is more about deterrent and retribution. Now, where from it has been derived? Now, people cannot write criminal law without having or without being influenced by the factors outside the law. That means, criminal law is nothing but essentially reflects the socio-ethical and moral values of the society. Now, those socio-ethical and moral values are something that is written in criminology, or that is something that the criminologist talks about or they discusses. So, from that point of reference, we can say that perhaps the Indian Penal Code was also influenced by the classicalist way of looking at things or addressing crime at that point of time. Now, the chapter 6 of his work, Beccaria advocates that a punishment is effective only when there is a proportionality between the crime and the punishment inflicted. He writes, it is not only the common interest of mankind that the crime should not be committed, but that crimes of every kind should be less frequent in proportion to the evil they produce to society. Therefore, the means made use by the legislature to prevent crime should be more powerful in proportion as they are destructive of the public safety and happiness, and as the inducement to commit them are stronger. In chapter 12, Beccaria further writes that the end of punishment therefore is no other than to prevent others from committing like offense. Such punishment therefore, and such a mode of inflicting them ought to be chosen as will make strongest and most lasting impressions on the minds of others, with the least torment to the body of criminal. Now, with this two kind of explanation that Beccaria gave was, you can find that the emphasis was not on anything like the correcting the criminal or reformation or rehabilitation of the criminal, rather the emphasis, rather the focus on was that the society should be kind of society should be saved from such tendencies among people. That means, the interest of the society or in the interest of the community at large, crime should be punished proportionately, and that is even that remains the even philosophy behind the criminal justice system today, that one of the approaches or one of the fundamental premises of criminal justice system is that it helps or it indeed is meant to protect individuals or the persons in society against transgression of their right to life and liberty. Now, another very influential person was called Bentham, who was an English philosopher and who was further influenced by Beccary's work. He in fact used Beccary's work to justify his penal theory contained in his seminal work An Introduction to the Principles of Moral and Legislation, 1789. Bentham developed something called a hedonistic calculus of pleasure and pain, and he defined punishment as a particular form of pain. The punishment was at once both deterrent and reformative. That means, with the help of this pleasure and pain principle, or what he has called as hedonistic calculus of pleasure and pain, the Bentham tried to explain the fact that if someone commits crime, on commission of that crime, the person derives pleasure. Now, that pleasure has to be outweighed, or that pleasure has to be adequately addressed by inflicting pain. That is the whole principle of pleasure and pain, or the calculation of pleasure and pain given by Bentham. Now, the pleasure derived out of commission of crime should be adequately addressed by inflicting pain with the help of punishment. That is what Bentham laid down. These two important philosophers or criminologists, I would call them, one is Beccaria and Bentham. They laid the entire the classical school, and of course, there were other people who were responsible for that, but the classicalist or the classical philosophy is influential even today. As I have told you, the criminal justice system is still governed by the tenets of classical school, as we have things like mens rea, that is the criminal intent. We have things like sentencing tariff. We have things like just desert. I think if you look at the whole the judgment or the particular death penalty discourses, you would find that just desert. That means, only in rare cases death penalty can be given. Now, where from these things have come? These things have come, these things have been derived from the very philosophical underpinnings of the classical school, for which classical schools still remain relevant. Now, what were the basic elements of the classical school? The basic elements of the classical school were, in every society, people have free will to choose criminal or lawful solutions to meet their needs or settle their problems. Now, people often tend to go for the unlawful means because they want to. Criminal solutions may be more attractive at times than the lawful ones, because the classicalists believe that they usually require less work for a greater payoff. Therefore, the person's choice of criminal behavior needs to be controlled with the help of the fear of punishment. The more severe, certain and swift the punishment, better able to control criminal behavior in society, and society will be under control. Now, this classical philosophers or the classical philosophy, it influenced judicial thinkers of the 18th and 19th century. Now, prisons started to be used as a form of punishment, and sentences were geared proportionate to the seriousness of the crime. Now, the focus of the classical school, number one was the free will of man, number two pleasure and pain principle as something given by Bentham, free will of man the Beccaria propagated, equal punishment for the same offense, that is something very important. There was no any different punishment, unlike we have for the same offense one can be released on probation, for the same offense one can be given the benefit of juvenile justice system. Such things or the similar things were not there when it was the case of classical school. Deterrent and definite punishment, that still remains the important parameter or important principle of criminal justice system, and the crime was defined only in legal term. These were some of the focus points or the focal points of the classical school. Now, for Beccaria, laws should be published. This is something that we need to look at. What Beccaria held was laws should be published. Torture and secret acquisition should be abolished. Capital punishment should be abolished. Rather, imprisonment should be there, and jails for human, no distinction between poor and rich. These were some of the focal points. Now, what happened was, the Beccaria's ideas were quite radical at that point of time, because the society was governed by more of the spiritualistic notion, or the religion is to be the driving force behind the social factors or the social processes or the social phenomena. So, it so happened that the Roman Catholic Church condemned his book in 1766, because he abandoned that spiritualistic notions of frame of reference, and in fact, his book was placed in the forbidden books in that church, I mean the religious place they used to have. Now, there were certain drawbacks of Beccaria's philosophy, but then to sum up the Beccaria's work here, the principles that he held were the role of legislature, which is very significant. The role of legislature that Beccaria held was to define crime and to define specific punishment. The practice that was prevalent at that time was legislature passing general laws, and implementation was left to the discretion of the judges. That is what the Beccaria opposed, that the crime should not only be defined, but also the punishment should be defined in specific term. That was what was held by him. Second, the role of judges. What Beccaria held was that on the question of determination of guilt only, the judges should have a say, nothing more than the determination of guilt judges should be concerned about. Third, the seriousness of the offense or the crime to be determined solely on the basis of the harm being caused to others in the society. The punishment is unjust when severity of punishment exceeds what is necessary to deter crime. Next is excessive severity not only fails to deter crime, but also actually increases it. Next, punishment should be prompt, the point I have already narrated to you. Punishment should be certain. Laws should be so structured that punishment would take care of, or the laws would take care of the aspect of crime prevention too. Now, from pre-classical ideas to the classical school, then came something called neoclassical. Though it is not a major school of criminology, but then we need to take very important cognizance here that neoclassical school for the first time, it had drawn the roadmap of that very paradigm shift of transition from classical to the positive school. That means it is called as neo because it was new classicalism. The manner we have something like neo capitalism today. So, it is a new version of classicalism, and the people who were related or associated with neoclassicalism were Roji, then Gorod, Joly, and what they did was they modified the central tenets of the pure classical school or theory by revising the doctrine of free will without avoiding it, but also including factors such as age of the criminal, mental culpability of the offender, child offenders, etc. That means, what we find mentioned in the Indian Penal Code, there are certain general exceptions. That means, it was not purely was a positivist school of thought, but then it started thinking in a manner that positivists started looking at or they thought of. The neoclassicalists, they primarily added certain factors which may be responsible for people to commit crime. That is why they have talked about mental capacity, or they have talked about the age of the offender, because the elderly people cannot be or should not be given the same punishment or with that of an adult. So is with the case of a child who is maybe at the age of 10 or 12 cannot be given the same punishment, though the crime being committed may be the same. That is the change in the philosophy or the shift in the philosophy that you can see from classical to the neoclassical. Now, thereafter came the very important and a very significant school of criminology that we call it as the positivist school of criminology. Before we delve into the positivist school in detail, it is important for us to realize that why is it called positivist. Now, it is called positivist because it was in this particular school of criminology was influenced heavily from the work of Auguste Comte, and the people who followed Auguste Comte, the father of sociology, came to be called as positivist. Now, what was there in the Auguste Comte's contribution of looking at society was that he started looking at society or the social phenomena more scientifically. So was the case with the positivist criminologists. They started looking at crime more closely from a very scientific perspective or with a scientific approach. Now, as I have told you, the founder of modern scientific positivism was Auguste Comte. To Comte, human knowledge emanates from three sources, namely the theological, that is supernatural entity, metaphysical, that is abstract ideas, single all encompassing ideas substituted for supernatural entity, and finally positivist state, which stands for all laws of knowledge and existence are derived from close observation of positivist phenomena or positive phenomena. Now, the very backdrop or the context in which the positivism or the positive school emerged is also important for us to understand. That was the time when there was rapid industrialization and growing capitalism in Europe, and certain conditions which prevail at that point of time, maybe things like juvenile delinquency, the kind of and prostitution and other the urban phenomena perhaps might be responsible for the emergence of positive school to some extent, and the propounders of the schools were namely, as you may be knowing about, Lombroso, Enrico Ferri and Garofalo. These three persons are called in fact the trinity in criminology. I repeat, Lombroso, Enrico Ferri and Garofalo. And the Lombroso is in fact called to be the father of modern criminology, because for the first time that the whole scientific thinking went into understanding crime in the society. And the biological positivism that was the whole Lombroso emphasized, or Lombroso started or he kind of propagated, was something that was later discarded by the social and the political understanding of the society or the thinkers. Even then, Lombroso's contributions still remain relevant because of the fact that for the first time someone started looking at things or looking at the phenomena of crime more scientifically, more empirically. Now, what really happened with the positivist school was, or the positivist classical positivist school of criminology was that, distinct from the classical school, they started looking at the person behind the commission of crime. That means, if you have seen the classical school, now classicalists, they relied on the crime which was committed, and what they thought was the punishment should fit into the crime. Whereas, these 3 persons alongside other positivists believe that there could be different factors responsible for making people to commit crime. So, rather than emphasizing on the crime what is being committed, the emphasis should shift from crime to criminal who commits the crime. That was a paradigm shift altogether we can see. Now, for that it was important to realize the significance of looking at the causes or the reasons of crime in different ways, namely biologically, that is what Lombroso, Enrico Ferri and Garofalo they talk about, psychologically, because there are psychological reasons behind commission of crime. That is where we find different theories of crime causation given by different people from time to time. You have the kind of Sigmund Freud who has talked about id-ego and superego, that one of the important theories of crime that we still have. We are going to discuss about that separately as part of our theory of crime lecture. But the point I am trying to draw your kind attention to here is that the biological, psychological, then there are also sociological factors, maybe because of social processes, maybe because of social structures, people commit crime. There are many brilliant ideas on sociological kind of positivism that we are going to take up as part of the theories. Now, there are also economic reasons of people committing crime. People may commit crime because the person may not be able to identify what is right and wrong if the person has got nothing to eat. So, an empty stomach may not be able to identify what is right and wrong before him or her. So, that may also be the reason for people to commit crime. So, therefore, when one has to define crime and also has to devise punishment, that punishment or the approach needs to take into account similar factors behind the commission of crime. That is what precisely the positivists talk about. That is what the positivists they affirm, that these factors behind commission of crime should be taken into account, and that is the shift or the change that we can see from classical school to the positive school. Now, this classical school was influenced by the 3 sets of ideas. You can say the notion of evolution and science by Charles Darwin, social evolutionism by Herbert Spencer, and scientific positivism by Auguste Comte. Now, Lombroso, as I have talked to you, I have told you, he is credited to have started this whole biological positivism, and Lombroso believed that the people who committed crime were primarily the biological throwbacks to an earlier evolutionary stage, and such persons were more primitive and less evolved than their counterparts. Now, another person, that Enrico Ferri, he talked about, or he rather relied upon anthropological, geographical and psychological and economic factors in explaining criminal behavior, and categorized offenders as insane criminals, born criminals, habitual criminals and criminals by passion. Similarly, with Garofalo, who categorized criminals as endemic criminals, criminals deficient in probity, lascivious criminals and violent criminals. Now, so far as the psychological positivism is concerned, as I have told you, the most important contribution has definitely come from this psychoanalysis theory by Sigmund Freud, who has talked about id-ego and superego. But in addition to Sigmund Freud contribution, we have other theorists also who have significantly contributed for the emergence of or for the popularization of the psychological positivism, like the frustration aggression theory, like the instinct theory of criminal behavior and so on and so forth. Now, as I mentioned to you, the social factors or the sociological positivism was equally influential. So is with the kind of economic factors. That means the things like the culture conflict. What is criminal law? Is criminal law essentially reflective of dominant cultural norms, or does it take in equal measure the concerns or the cultural ethos of all sections of the society. Now, this is something that was particularly about the cultural conflicts theory, which was propounded by Selin, about which we are going to take up in detail as part of our theory, crime theory analysis. But the point I am trying to bring to your notice here is that there were different ways of looking at the social reasons behind crime, and which have been grouped under social structural and social process theories. You have Chicago School of Crime, you have the containment theory, you also have theories like the labeling theory and so on and so forth. As a whole, to conclude this particular discussion, we can say that every facet of this positivist school of criminology is important, be it the biological, psychological, sociological or economic. And to understand criminology as it evolved over a period of time, we need to look at it more systematically from pre-classical ideas to the classical school, to the neoclassical school, to the positivist school. All this set of ideas and the philosophies together make it one of the most interesting domains to look at. And let me also tell you that to understand criminal law well, we need to understand the tenets or the founding principles of criminology, because that makes the whole study of criminal jurisprudence more interesting and more enriching. With this, I would like to end this particular lecture on schools of criminology. I will be taking up the theories of crime separately. Thank you so much.